On air light. All right, 20 seconds, everybody. Welcome, everyone. We are here on Tuesday, August 17th, 2021, to consider an appeal of an Historic Preservation Commission decision regarding a certificate of appropriateness for 125 Henderson Avenue. And I will ask the clerk to please call roll for us.
Davenport, Parker,
Here.
Link,
Here.
Wright,
Present.
Denson,
Here.
Poole,
Here.
Edwards,
Here.
Myers,
Here.
Thornton, Hamby.
Here.
We have a four.
All right, thank you, Madam Clerk. All right, order of business tonight is that we will have public input, and we have two individuals signed up. David Ellison as a proponent for the applicant, and George Daly as an opponent of the application. And then we will have any commission questions, and we have Attorney Judd Drake and Attorney Austin here to ask any questions of, as well as Planning Director Brad Griffin and Historic Preservation staff person Amber Eskew, and then consider a decision. So, Mr. Ellison, welcome to the meeting. Glad to have you here. The 10 minutes is yours.
Okay, thank you. David Ellison on behalf of the applicant. Before we begin this process, I just want to thank you all for letting me be here today. And also just draw one of the distinctions of how y'all are acting tonight and this appeal. Later on this evening, y'all will be serving in a legislative capacity to enact ordinances and resolutions and to govern this county. But at this appeal, you're acting in a quasi-judicial capacity to consider the ordinances that y'all have enacted and to consider whether or not the denial of this certificate of appropriateness was appropriate under y'all's ordinances. And so I bring that up because many of the issues I'll be raising this evening will be dealing with, has this applicant met the standards of the ordinance, and are these ordinances constitutional on its face and as applied? And so a little bit of history about this project. My client submitted this application for a plans review in 2019, went through that process, got feedback, resubmitted earlier this year. One of the key distinctions of this resubmittal was that the size and the height of the building were reduced below the roof line. So this was submitted, and unfortunately, the HBC decided to deny the COA. We believe that this was inappropriate and an abuse of discretion as a matter of statutory interpretation. I've raised multiple constitutional objections before y'all, but y'all do not have to address the constitutionality of those ordinances tonight. As a matter of statutory construction, y'all can and you should find that this COA should be approved. I've cited a few statutes in my notice of appeal, but as a general rule, any ambiguity of an ordinance needs to be construed in favor of the property owner and the free use of land. And these ordinances are ambiguous because in this instance, the applicant has satisfied multiple guidelines that should result in approval. Satisfied guideline 5B.2, roof forms, 3A.1, roof shape, 3A.2, roof slope, 3A.3, roof material, 3A.5, chimneys, 3F.3, foundations, 3G.1, corner boards, 3E.1, wood siding, 3G.3, column details, 5D, materials, 5E, details. And yet, after meeting all these guidelines, it was still denied. And so, due to these inherent ambiguities in the ordinance, this body should construe this in favor of my client and find that we have satisfied this standard. Ultimately, we believe that the HBC was unduly influenced by irrelevant and highly prejudicial comments by those who spoke in opposition to this. Those who spoke in opposition to this application emphasized the use of the property and the interior of the property. And both under Georgia law and local ordinance, those are improper bases for consideration for a certificate of appropriateness. And so that in and of itself resulted in this abuse of discretion because one person said, well, they're going to remove trees. The guidelines state that a COA is not required to remove trees. Other people complained about uses, and of course, that's not allowed under state law. Another neighbor just came out and flatly said they didn't like my client, and that's fine. This is not a popularity contest, but there's an unfortunate situation. We don't have the facts, you don't have the law. They chose to attack my client's character, and that is an improper basis to deny a COA. But ultimately, there are some constitutional issues involved here. The fundamental issue is that to satisfy due process, you have to have sufficient objective standards to guide an ordinary person as to what is to be expected of them. Y'all do this all the time with your ordinances. Think about some of the design standards that y'all have as to this is what your setback's going to be, this is going to be percentage, floor area, very specific standards and requirements that y'all have in those ordinances, but that's not here. Ultimately, this was denied for two reasons. One was it was quote unquote out of scale with the district. And so we know it can't have been denied for a reason of improper height because this new construction was going to be actually less than the roof line of the existing house. So if it's not going to be higher than the existing roof line of the house, then height's not the problem. Instead, the issue was the footprint. And I've put in front of all y'all this evening, basically this is what the guidelines say about the footprint. And that's it. Some are too big, some are too small. It's left for the applicant to figure out what is the Goldilocks moment when something would be approved. When is it just right? And because there's absolutely no ascertainable limits on how the HPC can interpret this guideline, that violates due process. It violates due process on its face and as applied to my client. Because there's simply no limits on whether or not this footprint is too big or too small. An applicant cannot just guess when it's going to be just right. The other issue is that this was denied because there's a quote-unquote false sense of history. How can someone correctly guess what is the correct sense of history? It's impossible. And so because they denied my client based upon some sort of guessing what is the correct sense of history, the false sense of history, that violates due process. When the HPC says this is a false sense of history or correct sense of history, they're inherently making an ad hoc and subjective decision. And Georgia law is squarely on point. That violates due process. Also raised another constitutional objection under the Georgia Constitution. This is separate and apart from the due process issue. And this is a matter of delegation of zoning powers. This body has zoning powers. Only this body can make decisions as to legislative discretion. And so in this instance, under this ordinance, this body has improperly delegated its discretion to the HPC. The ordinance says, if in the opinion of the Historic Preservation Commission, not y'all's opinion, HPC's opinion, the HPC's discretion. I've cited two cases under Georgia law, but this happens all over the country. Local government, this body, cannot delegate its zoning powers. And that's what's happening here. It would have been different if the HPC made a recommendation for y'all to decide. That happens all the time, and that would have been proper, but that's not the ordinances here today. And so when I brought up this distinction between a legislative and a quasi-judicial capacity, y'all can't make a judicial legislation today. My client is entitled to the ordinances that were in effect at the time it applied, and y'all can't fix this through some sort of interpretation. I've cited some matters of statutory interpretation in here that the legislator cannot say, a judicial body cannot just assume what the legislature would have wanted. An absent provision cannot be supplied by the courts, and it cannot be supplied by y'all acting in a quasi-judicial capacity. We applied for application for certificate of appropriateness for approval for new construction. That's what we want, that's what we need. We have no obligation to get approval for demolition. Ordinances call for demolition or relocation. And so to suggest that this is also some sort of quote-unquote partial demolition is requiring us to jump through two hoops when only one is required. Plus, it raises due process concerns because at what point in time does a partial demolition require you to go through this process? Is it 1%? Is it 50%? Is it 75%? When is it? Because there's no criteria there, that violates due process. So we're going to ask you to approve this COA. You don't need to get to the constitutional issues. You can find that under these facts, under this ordinance, that it should be approved. I've gone through about a dozen different guidelines that say this should be approved. Only issue was the neighbors don't like my client, and that's not a basis to deny a COA. Say it's false sense of history or improper scale. What's in front of you is the sole guideline on what is scale. And look at every other house next to it. Go down that road. It's going to be just as big as what my client is proposing. Many of them are asymmetrical. So to suggest that this is somehow improper or does not meet the ordinances is arbitrary and would be a constitutional violation as applied to my client. Thank you.
Thank you. Is George Daly in the building? I believe I had only a single one who was signed up. Mr.
Okay,
Daly.
I was going to make sure you, if we have more than one. Okay, good.
Good evening. Just state your name for the record.
My name is George Daly, and I wish to ask if I may remove my mask while speaking to you.
We can hear you fine. Yeah.
You can hear me fine
Yeah,
right
we can
now?
hear you well. Yeah.
All right. Thank you very much, Mr. Mayor, members of the commission. I live at 145 Henderson Avenue, which is 2 doors down from Mr. Clay's house. I believe that the Historic Commission acted just as it should have in this case, and I request that you affirm its decision. The house at issue was built in the late 1800s. An addition was added along Church Street sometime before 1918, so the addition is itself a historic structure. Mr. Clay seeks to demolish a large part of the addition and to substitute for it a larger and taller and architecturally more complex structure. He also seeks to add a west wing on the Henderson Avenue side of the house, which would increase the front length of the house by about 50%. The resulting house would be about 7,000 square feet, which is a very substantial increase over its present size. Your commission applied its design guidelines, which you have approved. First, it applied the guideline for demolition of a historic addition. That guideline provides that historic additions are important so that the public may see the evolution of a historic house up until the time that it becomes a part of a historic district. And that demolitions are especially important because a demolition may not be undone. The Historic Commission concluded on this issue after a discussion that the proposed addition did not meet the guidelines because the changes, which will be especially visible from Church Street, would create a more complex and a larger structure. The scale and the massing of the new addition would conflict with other houses in the district. It won't look historic. In my opinion, it'll look like a 1920s student rooming house. The commission then applied the guidelines to the proposed west wing addition. The existing appearance of the house from Henderson Avenue is of a medium-sized house for this neighborhood. It has a balanced facade with the front door in the middle of it and a dormer window directly above it with a beautiful stained glass insert. There are windows symmetrically placed on either side of the door and 2 symmetrically placed chimneys on the roof. The house sits right in the middle of its lot along Henderson Avenue. Everything is symmetrical, in keeping with a certain style prevalent at that time. With the lengthy pop-out addition, there would then be 3 chimneys and a non-symmetrical appearance to the facade. The commission concluded that the proposed changes were not allowable under the design guidelines because they would not be subordinate to the existing house and would give a false sense of the history of the house. In reaching these conclusions, the commission did exactly what it was supposed to do. It applied the ordinance to the facts. Your ordinance allows you to override its judgment, which was unanimous, only if you find that it abused its discretion. That did not happen. There is a solid basis in fact for what the commission did. The proposed addition would clearly alter the historical appearance of the house. The Historic Planning Commission was created to take some of the work off your plate. You have delegated to it the power to decide cases about changes to historical district structures subject to your ultimate review for abuse of discretion. All the evidence here shows that the commission did its job fully and fairly. If there was any abuse of discretion,
Yes.
I got about 10 more seconds.
You can finish your statement very quickly.
If there is any abuse of discretion, it was by Mr. Clay. It is he and his bulldog flip-flop party house who are abusing discretion by trying to seriously alter the appearance of an historical house.
Thank you, Mr. Daly. Mr. Ellison is agent for the appellant. You have an opportunity for a 3-minute rebuttal if you'd like to take that.
Shall I exit?
Yeah, you can sit in the chamber if you'd like.
I appreciate the gentleman's comments, but I just need to perfect the record and respectfully object to his legal standing to object his this application. Beyond that procedural issue, however, you don't need to take my word for it. You don't need to take his word for it. Look at this aerial photo that's in front of you. The gentleman complains about a west wing. 2 houses down on the same side, there's a west wing. Immediate house next door to the right, looking at this from the right, it's asymmetric. 2 houses down, asymmetric, goes out the back in the same manner as my client wants to do. 3 houses down, goes out the back the same way my client wants to do. 4 houses down, goes out the back, same way my client wants to do. Next house down, goes out the back, asymmetric, same thing my client wants to do. House that you can't see, it's kind of cut off, goes out the back, asymmetric, same thing my client wants to do. Across the street, kind of catty corner, I don't have the street number, but they go out the back, asymmetric, goes out the back, goes out the back. That's the exact same thing we want to do here. We know height's not the issue because the height is actually less than the existing roof line. The only issue is quote-unquote footprint. And that guideline that's in front of you is deficient constitutionally because it does not provide notice. It absolutely allows an HPC to make an ad hoc decision. It abused its discretion because it was given information that was improper from these neighbors who spoke in opposition to it, who just don't like my client and dislike the proposed use. This council has the ability to change the proposed use through its zoning laws. HBC is not in proper form for that. And so, based upon this evidence and these ordinances, the only way it can be is approval to avoid these constitutional issues under statutory construction. All these guidelines go in favor of my client. Only one that doesn't is this foundation, this footprint. It completely lacks objective criteria. So for that, we ask that you please approve the certificate of appropriateness.
Thank you, Mr. Ellison. Certainly entertain any input from members of this body, any questions you may have of our attorneys or staff, the applicant's agent for that matter, or certainly be willing to accept a motion at this time. Yes.
Mr. Mayor, I move to deny the appeal.
I'll second that.
Any further input?
So to clarify, Mr. Mayor, would you make a motion to find that Historic Preservation Commission did not abuse its discretion in reaching its decision regarding the application for a certificate of appropriateness for the property located at 125 Henderson Avenue and uphold the determination made by the Historic Preservation Commission?
I thought that's what I said, but
Yep.
yes, sir, thank you. Thank you, Attorney Drake.
All right. Motion to that effect from Commissioner Edwards and a second from Commissioner Wright. Would you like to make any further statement, Commissioner
Or
Edwards?
Commissioner Link seconded. Thank you, Mr. Mayor. And members of the body, please excuse my informality this evening. I was rushed picking up my son from school and working on a construction site. But nevertheless, I'd like to explain my position to deny this appeal, as Attorney Drake backed me up. The standard of review here, as described and delineated by the applicants, the abuse of discretion. And looking at the reasons cited by the Historic Preservation Commission to deny this application based on the fact that the proposed renovation would be out of character with the historic district and also the scale and the massing of the building. Now, when we look at the plans and see that the proposed renovation would perhaps more than double the size of the existing structure, and seeing again that the facade of the building would be changed by the renovation, those two aspects certainly resonate to me as a dramatic construction in this district. I know that the applicant purchased this home in this district, knowing that it was a historic district. And I guess I'd also like to elucidate that it's about historic preservation. We're preserving the structures as they exist. Comparing this historic structure to other buildings within the district has perhaps not the bearing that the appellant would have us believe. If we went down that road, then we could theoretically have historic districts that all mimic one house or one structure within that district. What's special about our historic districts is that they preserve the structures as they exist and provide protections for that when renovations are proposed, they are subordinate to the existing historic structure. If we were involved in a comparative exercise for each of these applications, we could pull a piece from this, oh, this house has this type of window, so let me do this. This house has this type of chimney, let me do this. No, that's not it for me. It's about preserving what's there. So for those reasons, Mr. Mayor, I argue for my colleagues to respectfully deny the appeal for this application. Thank you.
Thank you, Commissioner Edwards. As the seconder, Commissioner Link, would you like to make any further comment?
Yeah, I mean, to me, this is a no-brainer. There are multiple reasons why this appeal should be denied, and it's in violation of the design guidelines. The demolition criteria are not met. The part of the structure proposed to be demolished does not meet the criteria. It is a historic portion of the building. It clearly violates the footprint guidelines. It violates massing guidelines. It is not subordinate to the original structure. And also, there's a matter of style. This is a classic craftsman-style cottage. One of the primary qualities of craftsman-style cottages is symmetry and simplicity. And what the applicant is proposing violates all principles of symmetry and simplicity. So on that basis alone, I believe that the HPC was perfectly right in their decision.
Thank you, Commissioner. Any further input on this matter? All right, we'll have a roll call beginning with Commissioner Edwards.
Edwards,
Aye for
For your motion.
denial, yes.
Myers,
Aye for denial.
Hamby,
Yes.
Parker,
Yes.
Blink,
Yes?
Wright,
Yes.
Benson,
Yes.
Poole.
Yes.
8 yes, 0 no.
All right, thank you, Madam Clerk. All right, all business being complete for the special called session, I'd hear a motion to adjourn.
So moved.
Second.
All right, I have a motion from Commissioner Wright and a second from Commissioner Edwards to adjourn until 6 o'clock. All in favor?
Aye.
Any opposed? All right, hearing none, we are adjourned.